Hello everyone. Today in this video I'm going to discuss about the provisions of postal ballot that is given under section 110 of the Companies Act 2013. Now basically what is postal ballot and why is it introduced or why is it incorporated under the Companies Act 2013 or also in the earlier act, that is Companies Act 1956. So basically postal ballot is just an alternative way of voting in shareholders meeting, and the main object of postal ballot is to encourage more number of shareholders to participate in the voting, so that they need not it's the privilege that has been provided to the shareholders that they do not need to come to the meeting venue and give their vote. Rather, they can also vote through postal ballot. So let us discuss the provisions of the same. Let's proceed with it. Now, Section 2, Subsection 65 of the Companies Act, it defines the postal ballot, and it says that postal ballot is a casting of vote by a shareholder by postal or electronic mode. So there is no requirement of being personally present for the voting purpose. So basically, postal ballot is like for casting of vote by a shareholder either through postal or electronic mode. Okay. Now, what does Section 110 provides, or what does it tells us that the members in the members meeting there are few businesses that needs to be passed only through postal ballot, and there are few resolutions that cannot be passed through postal ballot, and the other, it's the option of the company whether they want it to be passed through postal ballot or not. So we'll be discussing these topics today. Let's move forward. So it says a section 110, that is subsection 1 of section 110, it provides that the central government may declare item of businesses that can be transacted only by postal ballot. So these are those resolutions which the central government has prescribed, which can be transacted only through postal ballot. And where have they prescribed? In the rule. So we'll be reading it afterwards. Secondly, in respect of any items or businesses other than the ordinary business, or any business in respect of which director or auditor have a right to be heard at any meeting, may be transacted through postal ballot. So now it's the discretion of the company. They can uh, pass and they can transact any business through postal ballot apart from ordinary businesses, or any business in which the directors or the auditor have the right to be heard. So we'll be discussing it later on. So first of all, section 110 which deals with the postal ballot provisions, it says that there are few resolutions or few businesses that the central government prescribes which needs to be passed through postal ballot only. There are few resolutions which cannot be passed by the postal ballot, and thirdly, there are all other resolutions are at the discretion of the company whether they want it to be passed through postal ballot or not. Okay, so this is the bifurcation. Today I am giving you the explanation of this postal ballot topic, just because, so that at one place you can find all those resolutions which can be passed through postal ballot or which cannot be passed through postal ballot, so that you can find all those at one place, and you need not go here and there to locate them. Okay, so let's move forward. Like I said, certain businesses are there which can only be transacted by postal ballot, and these have been provided by the central government. So if it is prescribed by the central government, then it will be obviously in the rules. Now, Rule 22, Sub Rule 16 provides for the list of businesses that can be transacted only through postal ballot. Now, let's see what are those businesses. First of all, alteration of object clause of the memorandum, and in case of the company in existence immediately before the commencement of the act, alteration of main objects of the memorandum. So why is this bifurcation given? Because in the new act there is no such separation like main object, other object. So if the company is a newly incorporated company and the alteration of its object clause is required, then it has to be transacted only through postal ballot. Secondly, If the company is in existence before the commencement of the act, the alteration of the main objects of the company requires to be requires the postal ballot transaction. Like it should be transacted only through postal ballot. Okay. Secondly, alteration of articles of association in relation to insertion or removal of provisions under subsection 68 of section 2. So now subsection 68 of section 2 provides for the private company. So if there is any insertion or removal of the provisions, and because of that the articles of association is altered, then that has to be provided or that has to be transacted only through the postal ballot. Okay. Thirdly, change in place of registered office but outside the local limits of the city. It is provided under section 12. So if the case is of change of registered office but outside the limit of the city, town or village. Okay, then another point which has to be passed through postal ballot is change in objects for which the company has raised money from public through prospectus and still has any unutilized amount out of the money so raised under subsection 8 of section 13. Okay, so it says that the change of like section 13 subsection 8 provides that if there is any change of object and for that change of object the company has already raised raised its money through prospectus, and there is still some unutilized amount of money, so that has to be passed through postal ballot. That business has to be passed through postal ballot. Now another point is issue of shares with differential right as to voting or dividend or otherwise. So if the company is issuing any shares with differential right, then it has to be passed through postal ballot. Now another point is variation in the right that is provided in the section 48. Okay, so if there is any variation in the right, like if the class of the shares are being changed or any variation in the right that is attached to the class of shares or debentures or any other securities, so for that also, for that business, the postal ballot is required. Another point is buyback of the shares. Another is election of the director under section 151 of the Act. Okay, now important point is section 181A, which say that is section 180 subsection 1 and clause A, which provides sale of whole or substantially the whole of the undertaking of the company, which requires an SR, that is a special resolution. So that also requires to be transacted through postal ballot. Another is provided under section 186 subsection 3, that is for giving of loan or extended guarantee or providing security in excess of the limit. Okay, now what is the limit? That is 60% of paid up share capital or free reserves. Okay, so that also needs to be passed through postal ballot. Now the question is not, it is not applicable for all the companies. That is the mandatory requirement of postal ballot for the businesses I stated above. It is not for all the companies. Like it is exempted for OPC, that is one person company, and all other companies which is having the member up to 200, that is 200 or below 200. If the company is having the members lesser than 200, then they are not required to transact the above matters through postal ballot. Okay, so the which what does it provides, or what does it say, is that any company having more than 200 members requires to pass the above stated resolutions or above stated businesses through postal ballot. Okay, and that is mandatory because of the prescription of the central government in the rules. Okay, so let's move forward and see another point. Now, in the starting of the topic, I mentioned that apart from the prescribed matters, that is, which are mandatorily required to be transacted through postal ballot, there are certain matters which cannot be passed through postal ballot. That is, it's the exception of section 110, and it is provided in the same section only. I've also read it in the starting. So let's see what is it. That is, the company can transact any business by means of postal ballot except the following. So these are the exceptions. Sorry. Let's start. First of all, ordinary business. Okay, so ordinary businesses, as I have already discussed, what are ordinary businesses? Declaration of dividend or retiring of um, appointment of director, that is other than appointment of director in place of the retiring one, or the appointment of auditor, okay, and its remuneration, or the adoption of accounts. So these are the ordinary businesses that is transacted only at the annual general meeting. So they cannot be passed through postal ballot. Okay. So this is provided under section 110 subsection 1 and clause B. Okay. So 110(1) B provides that there are few businesses that cannot be transacted through postal ballot, and they are, first of all, it is ordinary businesses, as I've already discussed. And the second is any businesses in respect of which directors or auditor has the right to be heard at the meeting. Now the question arises, what all are the businesses in which the director or the auditor has the right to be heard? Okay, so in case of the director has the right to be heard under section 169 subsection 3, which says that before the removal of the director from his office, he is required to be heard, or he gets the opportunity to be heard. Okay, so in that case, that business cannot be transacted in the through the postal ballot. And another point is, like, auditor has the right to be heard. So in what all businesses auditor has the right? First of all, in section 140, which provides for the removal of the auditor, wherein the auditor gets the opportunity of being heard. So in that case, those resolution cannot be passed through postal ballot. Or section 146, which provides any matter that is concerning the auditor. Okay, so in that case also auditor has the opportunity of being heard, and that business cannot be transacted through the postal ballot. Okay, now 110 subsection 2 provides that if the resolution is passed by the requisite majority through the postal ballot, then it shall be deemed to have been duly passed at the general meeting convened in that behalf. Okay, so if the resolution is passed through requisite majority, then it shall be deemed that it has been passed at the general meeting only. Okay, so this is about the businesses that requires to be transacted through postal ballot. They cannot be transacted through postal ballot. Now, one more point which section 110 subsection 1 and clause B says, that all any other businesses apart from the ordinary business and any business wherein the director or the auditor has the right to be heard, apart from these businesses, it's the discretion of the company that whether they want to hold it whether they want to transact any business through postal ballot or not. But section 110 subsection 1 and clause A provides that those lists which the central government has prescribed, those businesses can be transacted only through postal ballot, so which I have already discussed earlier. So we are not discussing here about the procedure of postal ballot because it's very theoretical and it's easy to understand if you read the rules. It has been prescribed in rule 22 only, that what is the procedure of postal ballot, okay, of conducting the postal ballot. If you will read it once, then only you will get to understand. But still, if anybody wants that I should explain the same, then you can comment on my video and ask, so that I can prepare next video for the same. So till then, it's all, and I hope that you have liked my video, and if yes, then please like and subscribe. My YouTube channel is PH Webgyan Videos, and do not forget to share and comment on this video. Take care. Bye bye. Thank you.